A very good afternoon to everybody. Okay. I'm pleased to welcome you all to this meeting today. I think it's a great opportunity, of course, to discuss the key points of the system of clinical education in Italy. In Italy, we are the first steps, of course. But first of all, let me express my gratitude to Professor Einaudi, who is here with us today.
It's the other way around.
And let me extend also my warmest greetings and my welcome to the other colleagues who came from other Italian universities. And I think that the aim of this seminar is to take the stock of the situation and to share our problems, to share our experience, and thanks to Professor Oppenheimer, to improve our solutions. I think it's our first year. I don't want to reveal in advance what Turin is going to tell us about clinical programs in Turin University. We are the first year. This was the first year, so we have some problems. Of course, this is an obvious remark. Perhaps some of the students could express some criticism. I invite them to do this in the second part of the meeting. But in my personal opinion, I think that if you want to change something, you need to start. And we started with 3 clinical programs, one in immigration law, one in family law, and one in prison law. We had some problems, as I said, for example, for what concerns the achievement of the validation of credits for our students. For example, we'd like to sign a convention agreement with our bar council, but there are some problems. And, well, for example, we'd like to extend this experience to other fields, but I think we can't afford to pay tutors or private institutions. So, I let you speak. It's time to stop. Perhaps these are some issues for our next discussion. And so, thank you, everybody, and thank you, Professor Oppenheimer, of course. I leave you the floor.
Okay. Grazie. Thank you very much for inviting me and for organizing this. Thank you all for putting up with my addressing you in English, and I will try to speak slowly enough that I will be comprehensible. I grew up in New York City, where we tend to talk very fast, but I now live in California, where we're very mellow, so I will try to speak slowly. And I hope that if I am not speaking clearly, you will tell me. I've been thinking about how do I describe the state of clinical legal education and the role of clinical legal education in the United States most effectively. And I realized that it might be best to simply tell you my story of my own experience in clinical legal education, and to use that experience as an illustration of where it's been, how it's developed, and where we are today, and a few of the challenges that we face, and a few of the challenges that we have faced in the past and we have now largely overcome. And I hope this is an interesting organization for you. So I should begin by saying that I was an educator before I was a lawyer. I spent 2 years after college and before law school as a high school teacher. And that turned out to be very important for me because I learned from my relatively disinterested, unengaged students who could think of many more important things to do than attend class, that learning by doing was a very effective way of engaging them, and in turn a very effective way of learning. And that's been part of my own approach to education in the time since. So one thing I'd like to do right now is ask how many of you are instructors or professors at law schools? So let me just see and how many of you are students? Good. And among the students, how many of you have taken a clinic course of some kind or worked in a clinic? Most of you, okay. And among the professors and instructors, how many of you work in a clinic as part of your work? Okay, and how many of you are interested in this topic, but you haven't worked in a clinic at this point? Okay, good. This is very helpful, and I hope you were sort of looking around the room. Those of you who are in the back of the room gain the advantage of seeing whose hands went up. Normally the advantage is to sit in the front, not in the back. So we'll mix things up a little later in some way. After high school, I went to law school. I had the privilege of attending law school at Harvard, and Harvard's Legal Aid Bureau just celebrated its 100th anniversary as the oldest law clinic in the United States. And like many law clinics in the United States, it was founded by students with something between opposition and indifference on the part of the faculty. And let me ask, how many of you have been involved as students in starting a clinic? One hand, okay. Maybe two, okay, you're very good. Well, at Harvard 100 years ago, a group of students started a clinic because they said there is a need in our community for people who don't have legal representation to get representation, and we're tired of just sitting in class listening to professors. We'd like to start doing something in law. And so they started the Harvard Legal Aid Bureau, which now sees hundreds of clients every year. There are 50 students every year who work in the Legal Aid Bureau. The law school, when I was there, the law school was still not providing faculty for the Legal Aid Bureau or giving us credit, but in the years since, the law school has fully come around, and now there are staff attorneys who are also members of the law faculty, and students working at the Legal Aid Bureau receive academic credit for their work. When I graduated from law school, I went to work for the California Public Prosecutor's Office that worked in the area of anti-discrimination law. And 4 years after beginning my practice with the state, there was an invitation from the new dean at the Berkeley Law School for our state agency to work with the law school in starting a law clinic. And this was partly because the dean was someone who thought that clinical legal education was a good thing and wanted Berkeley to have a clinic experience. And it was partly because students had sat in his office and demanded it, and he wanted them to go back to class. But in any case, the result of that is that in part because I had had the year at the Harvard Legal Aid Bureau, and also because I was the only person who thought this was a good idea, I was invited to come from this agency and become an instructor at Berkeley Law and become the first director of their first in-house clinic. And I had 4 wonderful years there working with 12 students a semester, prosecuting discrimination cases. The students did a terrific job. We were very productive. We all learned a lot. And when we elected a new governor of California who was more conservative than the prior governor, the clinic was closed because our work was regarded as too politically provocative. And so that's one lesson about law clinics, is that if you're going to do work that engenders political opposition, you have to think about how you're going to counter that opposition, because I was ultimately ineffective in countering that opposition. Fortunately, the church came to my rescue. A Jesuit law school in San Francisco said, well, we'd like a civil rights clinic, and so since you're leaving Berkeley, I got a little bit of attention in the process of leaving Berkeley. And so they said, why don't you come and have a civil rights clinic here? And I did. And I did that for 3 years. And I learned what I think is lesson number 2 to those of you who are clinical instructors and who are not full professors. There was this big gap between those of us who were working in a clinic and those of us who were in the law school as professors. And there was a big gap in status, there was a big gap in our security of employment. And part of the problem is that as a clinician, I wasn't expected to be an active scholar. But once I found that I was in this academic environment, it seemed to me that I had to write. It simply was part of being in this environment. And I was writing about racism and anti-racism and the law of race and the law of discrimination. I was writing things that were provocative and unpopular with my faculty. See, it's amazing you invited me, but my whole history is one of being unpopular. We'll see if I'm asked to leave my next job. But in any case, the result of that is that I realized that I really needed to move out of the clinic and into a position where my academic work would be regarded as important. And so I left the University of San Francisco and I moved to another university located in San Francisco where I was on the tenure track. I left clinical teaching for a period of time, but I tried to bring what I'd learned in the clinic about learning by doing into my classes. And so I used a great deal of simulation in teaching doctrinal courses. And eventually at that school I was granted tenure, I was made the associate dean, and that gave me the opportunity to help support the founding of 2 full-time law clinics at that school with 4 full-time faculty who had the same status as any other members of our faculty. They were professors of law, and their role was to run our clinics. And one was a workers' rights clinic, and the other was what we called an environmental justice clinic, but it might more accurately be called an environmental racism clinic. And the purpose of that clinic was to represent communities of color, poor communities of color, where factories were being sited and factories were being built and pollution was being allowed because they didn't have the political influence to stop it. So in San Francisco, when they needed a new power plant, they weren't going to build it in a white neighborhood, they were going to build it in a black neighborhood. And you know, in the United States, most neighborhoods are segregated by race. And so this clinic went to work trying to prevent that phenomenon. And they did and continue to do absolutely terrific work. One of the things that I was able to do as the associate dean at this other school was to develop, in addition to supporting our clinics, was to develop a whole series of programs in the area of experiential education. And by that I mean courses that involved learning by doing and simulation, and courses in which we were studying the practice skills of the legal profession. So courses in trial practice, courses in appellate practice, courses in pretrial practice, courses in negotiation, courses in advanced legal writing. And because I'd been doing that work, and because I had been serving as an associate dean, and because I had a background as a clinician, and because I continued to practice civil rights law a little bit, taking a case now and then, 5 years ago, the faculty at Berkeley recruited me to come to Berkeley and take charge of all of their experiential learning courses and programs, with the exception of their in-house clinics. So let me turn to describing the in-house clinics at Berkeley, and then I want to describe the other things that we do that are sort of semi-clinical. and then say a word about challenges and get on to the interesting stuff, which is you're getting to talk to each other about what you're doing. So, just as at Harvard, a clinic was founded because students demanded it, and just as at Berkeley, a clinic was founded because students demanded it. After I left Berkeley, the students organized a clinic that was independent of the university. They organized a community law center. And they then persuaded the law school and the University of California to provide monetary support for the community law center. That center has now grown so that it has 2 full-time law professors, 12 full-time staff attorneys who have the title of lecturer within the law school, 8 or 9 different clinic projects, and 60 students every semester working on cases involving poverty law and immigration law and juvenile law and family law and welfare benefits law and housing law and anti-discrimination law, and I always miss a couple. But I'm doing quite remarkable work. Work that takes us regularly not only into administrative courts and administrative tribunals, but also into the civil courts and into the courts of appeal. And the newest clinic within the Community Law Center is a public policy clinic, because of the recognition that we are again and again and again seeing the same kinds of problems, and the solution to them may be public policy solutions. Thank you. And so we are working on lobbying as well. In addition, within the law school, we have 3 in-house clinics, and we have 6 full-time professors who work in those clinics. One is a death penalty clinic. You don't need that here. In the United States, we have thousands of people who are on death row. And a significant number of them are represented by students and professors at Berkeley Law. And we haven't lost one yet. We have an international human rights clinic, which has done a wonderful job, for example, of exposing the impact of the Iraq War on Iraqi citizens who worked with the US military in Iraq. And a wonderful job of investigating what's happened to prisoners from the US prison in Cuba.
Guantanamo.
Thank you, Guantanamo. What's happened to prisoners released from Guantanamo who've returned to their home countries. And we have an intellectual property and privacy clinic, which is very involved in, among other things, in the Google Books litigation. So these are clinics that are doing important work with faculty working side by side with students and supervising students in this work. But in addition, starting around 25 years ago, students started arriving at Berkeley, and in their first week of school, went to the dean and said, "So I'm ready to work in the clinics, so how do I sign up, because I want to work in the clinic, because I want to be a lawyer?" And the dean said, "Gee, I'm sorry, but under the regulations of the American Bar Association, you can't work in the clinic until you're in your second year of law school." To which the students, being Berkeley students, said, "Well, to hell with that, we'll just start our own." And they did. And so when I got to Berkeley 5 years ago in my current job, I discovered that there were approximately 20 student-initiated and student-directed clinics in which the faculty had no role at all. And sometimes, neither did any lawyers. Our students were just going out there and practicing law on behalf of clients with no supervision, no permission, in utter violation of the state bar rules, in utter violation of the rules of professional conduct, in utter violation of state law, and without a whit of concern. And so soon after I got there, a number of my colleagues said, so Oppenheimer, you're in charge of all experiential education here. What are you going to do about this? And so I met with some of the leaders of some of these student groups, and I said, well, you know, maybe we should try to get you organized a little bit. And they said, predictably, screw you, excuse me. You just want to take us over and close us. We don't want anything to do with you. And so one of the great challenges of the last few years has been that we have actually managed, by bringing resources to the student clinics, to persuade them that it was in their interest to work more closely with us. And the one thing that we insisted on is that we find for them, or they find with us, supervising attorneys. And now each of these programs, there are currently 22 and there are 3 more in formation, and each of them has 1 or more supervising attorneys, and I work with all of them loosely, not telling them what to do, but trying to help support the work that they do, and their work is really quite remarkable. There's an asylum clinic in which they represent 30 or 40 people a year in asylum hearings, with a very, very high record of success. Many of their clients are sub-Saharan African refugees who are gays or lesbians and are very fearful of being returned to Africa, to their home countries. And when the program was started, it was called CARC, the Central American Refugee Clinic. It's now called CARC, the California Asylum Refugee Clinic. As refugees from Central America have been somewhat displaced from refugees from all around the world. And they're going strong and they're doing wonderful work. They're actually doing it in conjunction with, again, with a church group. There's a project that goes into Berkeley High School and works with the students there on a restorative justice project for student discipline. There's a group that goes into the juvenile prison. We put a lot of kids in prison in the United States, starting at around age 13. And we have students who go into the local juvenile prison and work with kids there and help train them in understanding their legal rights. We have a project that represents students who are being expelled from school, which again, it's very common in the United States for students aged 13 through 16 to be expelled from school, and it's mostly minority kids who are being expelled. And we now have a project that represents them. We have a housing rights project that advises people about housing rights, and a consumer rights project. And all of these are student-run. And that's why I was curious as to how many students here are here today, because if you were at Berkeley, you'd not only be taking clinic as soon as you were eligible, but before that, you'd just be starting your own. And the local bar has acquiesced in all of this and has become a big supporter of clinical legal education. And now we have, at this point, I have in my experiential education program 50 lawyers from our community who teach courses for us in topics like negotiation and trial practice and advanced trial practice and appellate practice and deposition practice and negotiation. We have 16 sections of negotiation law every year because we keep it to 20 students each. And so we've got over 300 students studying the law of negotiation each year. All of this, by the way, done on a shoestring because it's essentially volunteer lawyers from the community who are appointed as lecturers but are paid a pittance of a stipend. They're happy to do it, they're successful lawyers, and they want the experience of being back in the classroom. All of the teaching is done through a learning by doing approach to teaching. All of it is done through simulation. Simulation is now entering the regular curriculum as well. I teach first year civil procedure. my students, the first day of class, which is their first day of law school, participate in the simulated interview of a client, and over the course of the semester, we take that client's case all the way through to pretrial and to a negotiated settlement, and the course is built around the simulation. And so a word about challenges and what's happening that's new, and then I've used my time and probably more. And that is that the legal profession has now taken the role of those students who are sitting in the dean's office. And by that I mean the California State Bar has voted to require any student, any law graduate who wishes to take the California Bar exam, to sit for the exam and become a California lawyer, that student has taken at least 1/4 of his or her academic units in the second and third year of law school, either in clinic or in simulation courses that were built around the practice of law. The American Bar Association has said that in order for an American law school to give the doctorate degree, students have to have had either a clinic or a field placement or substantial units in simulation courses. The New York State Bar has said that students have to have at least 50 hours of experience doing pro bono work before they can sit for the New York State Bar exam. And other states will be following suit. And the legal profession is saying to those of us who are academics, and in some cases would really just write our books and articles and lecture, no, you can't do that anymore. We want you, as part of your responsibility, to be engaged in the professional training of our students. And it's not that we want you to stop being scholars and to stop writing and to stop thinking about new ideas, but we also want you, through your universities, to engage your students in the work of the legal profession and to begin training them in the values and in the skills of the legal profession. And that's what's happening in the US, and I hope that was a good use of your time, and I thank you.
Thank you, David. Thank you very much. I would like now to profit maybe from this moment that you're here to deepen some of your things and thoughts that you just gave us, and open up the possibility for discussions and questions that you might have.
I just have a remark, which is that for students here to start a clinic without being a lawyer, like, you know, as you said, happened in Berkeley, it would be kind of strange, because what happens is that here you always need an attorney to represent yourself in court. There you can self-represent. I mean, you can represent yourself, which means that if you have some students that help you, that's fine. Here you always need a lawyer. So, I mean, it's kind of you know, difficult to have something like what happened in Berkeley here, for this very reason, I think.
Although many of our student-initiated projects do not represent people in court, they provide general legal advice. For example, they have a project where at the Berkeley High School they have been put in charge of student discipline. And in turn, they have turned the question of student discipline over to the students. And so a group of students, under the supervision of Berkeley law students, run their own disciplinary system on a principle of restorative justice. So instead of suspending and expelling students or forcing them to spend time in study hall as punishment, they work with students to come up with creative ways of helping students who've misbehaved to correct their behavior. So there's no requirement, they're not engaged in law, but they're using an approach to law and legal problem solving to help avoid turning these student misbehavior problems into legal problems.
Maybe you can add something also, because I remember you were also involved in the students' organized clinic in Hamburg, which actually it has the same in Germany, has the same problematic that we face here in Italy, where you can't represent as a student any client anyway.
Right.
But in Hamburg they actually started the clinic out of a students' initiative, and maybe you can say much more because you have been involved.
So these students at Bucerius? Bucerius,
yeah.
Okay. There were a group of students who were working with a local charity, just doing volunteer work, and they recognized that many of the people who the charity was helping were migrants who had legal problems. And so they said to the organizers of the charity, isn't there something we can do about their legal problems? To which the organizers of the charity said, you're the law students. And so they went and found lawyers in the Hamburg community who said they would be willing to help work with these migrants on their legal problems if the students could work with them and if the school would approve it. So they then, with this, went to the dean, and the dean said, this is a wonderful idea, absolutely, we will support this, and the school actually now, I think, pays a part-time lawyer to work with the students, but it's mostly the students who are running it, but they're doing it hand in hand with lawyers from the community, most of whom are doing it on a volunteer basis or for the fees paid by the state under some circumstances, and working very closely with this local charity.
Yeah.
And it's become a big program there.
And another concern that I have is that maybe, if you start civil procedure or criminal procedure in this way, maybe it is like, you start by doing like a trial or something like that. That maybe it becomes too technical. Like, you do not really teach kids how to think about, the trial and the procedure, and you put them too much immediately into the mechanism without making them see it from outside, which I think is very important.
I'm sorry I didn't bring one of my students with me. But I think you're absolutely right that how we use simulation is important, and we don't want our students to think that this is all about style and technique. And so, for example, in the simulation, I've published a book of materials for teaching civil procedure, which I hope you'll request a copy from Foundation Press. Or I have a website, Foundation has a website called just www.civilprocedurecasefile.com. No spaces, just civil procedure case file.
Could you repeat, please?
Yes.
There,
well, let's write it down. Can I type on here?
Someone can see something.
Oh, this is somebody else's presentation. I'm sorry. Okay. So. And now, can we actually, let's see if that works. Can we link it?
Okay. It's okay.
So,
No, I don't have.
Oh, okay. Well, but what
I don't have internet.
what I do with this material is after the students watch the interview with the client, and after they study the cases from the U.S. Supreme Court concerning the sufficiency of a complaint, I give them a complaint in her case in which there are 2 or 3 paragraphs missing. And those are the 2 or 3 paragraphs that they have to add in order to satisfy the legal requirements of sufficiency. And I have them do it as a group, and then I give them a sample of a complaint which has met those requirements. So they have to actually think about what do these cases mean when we're dealing with the facts of an actual dispute. And what is it that I have to allege in a complaint in order to satisfy this rule as interpreted by these decisions? And I do that with a series of exercises where in each case I give them most of it, but what I don't give them is that kernel that requires some original thought on their part, as opposed to simply doing the technical thing of the drafting. And it's worked pretty well, I think. The students think it works great. You know, one can argue that they're not in a position to judge because this is the only civil procedure class they've ever taken. So, but they.
Anyway, you try to find a way to make them think,
Yes.
and not only pursue like a straight path.
That's right.
Okay.
That's right.
Fine.
And to make them laugh,
Okay.
because if people learn more when they're laughing.
Sure.
Yeah.
Okay, I'll just other questions. In the meantime, when you can reflect, please come up with a question. Also, students, it's not only an event that we all have to be closed. I have a question. Maybe you could describe a bit how the profession, let's say, called it like this, of a clinical professor evolved in the United States, how they were seen in the beginning, how they are seen now. Is there a difference between a full professor, how they are inside of the law faculties? I think this is something which is also quite interesting too.
Well, what's been very interesting is that initially law faculties were perfectly happy to have clinical professors, but didn't feel that clinical professors should be given the same status because clinical professors, for the most part, were not active scholars. On the other hand, the legal profession, and in particular the American Bar Association and the Ford Foundation, were very adamant that clinical professors were performing a very important role and should have equal status within the university. So the profession was saying, you have to treat clinical professors the same as others. What's happened is that as the role of clinical professor has evolved, most clinical professors now engage in at least some serious scholarship. Sometimes it's a distraction from the clinical work they do, but it's a necessary sacrifice for those for whom it is a sacrifice. And on the other hand, for some of us, I mean, I can't imagine not writing. I can't imagine a life in which I don't write. But I also can't imagine not practicing law, given the training I've been given. And so, you know, for people like me, it's been a godsend. My status at Berkeley is almost exactly the same as that of any other member of the faculty. Not quite, because within the law school, I have tenure, I'm paid the same, I get the same sabbatical schedule, I get the same research assistants, all of that. But within the university structure, I am not regarded quite in the same way. And that's something that we're working on. And I would say that currently in about half of US law schools, clinical professors are treated precisely the same, and their title is simply Professor of Law. And in the other half, it varies. But if the profession, if the ABA had its way, there would be no distinction at all.
What about your questions? Yes, please.
But I have a question which may sound a little bit silly, but I would like to know what is the opinion of Professor Oppenheimer towards private funding of clinics. Because in Italy, we have a constant and proportional decrease of public funding because we have a system which is, of course, different from the American and the system of the United States. So I want to know if for you it is a good, like a nice way to give us instruments in order to improve our skills. Because especially in the southern part of Italy, we have just some experiments of legal education. In Teramo, we are University of Teramo Law Clinic, in labor law, and the other one is in Palermo, but we just don't have enough funding, maybe, in order to have maybe attorneys to support us or something like that.
So this is a great challenge for you, I recognize that. In the United States, there is a culture of private giving to universities. And in the 1970s, there was a big growth of law clinics because the Ford Foundation decided that they would spend several $million founding law clinics as a way of enforcing the law reform efforts that they had funded in the 60s in civil rights and in poverty law. And they thought this would be a good way of helping to enforce some of these new rights. And then in the 1980s, the US Congress decided that they would establish more clinics and support clinics with state money, mostly because of a single congressman who was very powerful, who believed in clinical legal education. But since the 1990s, most of the money for clinical legal education either comes from the dean saying, okay, some of our faculty budget is going to be spent on clinics because they're essential, or private money from donors, often alumni, that is often graduates of the school. And if you go look at the website of any top American law school, they will have all kinds of information about their clinics. That's for two reasons. One is that students want clinics, and so it's being directed at prospective students to get them to apply. And two, the alumni want clinics supported, and so they're trying to appeal to the alumni so that they will make gifts to the school to support their clinics. And one of the major ways that we raise money at Berkeley, Berkeley is a public university in which the law school gets 16% of our funding, that's 16%, from the state, and 84% from private money. And we're a public university. And a lot of the money that we collect is money from people who are very pleased with our clinical program and our experiential learning program and want to support it. But you need a culture of giving, and you need to develop that over a period of time. You know, for your next meeting, don't invite a clinical professor. Invite someone who is a professional development officer, a fundraiser, to come and talk about how do you raise money. Maybe somebody from the Open Society Institute, who I know is helping support this meeting. And Costanza Ermanen is, I think she walks on water. Can I say that in Italy? But she's with the Open Society Institute and involved in funding clinics here in Italy. And she was one of my postdoc fellows at Berkeley a few years ago when she had a Fulbright there. And she's just incredible. Get her involved in helping you think about how do you raise private money, because it's absolutely essential. Unless you discover oil off the coast of Italy, that would also work. But I think mostly, well, okay, yeah.
But don't you think that this is just a way for the state to disengage from duties? It has like, you know, oh, okay, let's keep to the clinic the duty to defend poor people. So, you know, in the United States, the lawyers for the poor people are very poor paid. And to have a good Berkeley program for defending poor people is just what, you know, the state would like to have. But I don't think this is really, you know, a good, it's like helping the state to disengage.
Can I add something to this? Because this is a good point, which also reminds me to some important issue that I think it's always related to clinical education. The focus on social justice issues. At the same time, the problematic of this focus is obviously the point that you just mentioned, that at some point the state is trying to disengage, and we have seen something like this in Europe as well, in Poland. I will talk about this especially in a minute, where you really see that at some point they somehow disengage from this engagement of a legal aid system to develop a fundamental legal aid, state-funded legal aid system. But at the same time, I also think it is absolutely crucial that we all focus on this social justice issue in the clinical world. And I would like to hear what your focus is.
So 2 things. First, I think it's important that law school clinics have as their first function the education of our students. And while most clinics have a social justice mission, there's nothing more important for us as educators than the education of our students. Now, are we, in a sense, allowing the state to disengage when we supply these legal services to poor people or people who have in some way been victimized? In the United States, for the most part, those people would otherwise not receive any representation. It's not that the state would recognize an obligation. The state doesn't recognize an obligation. There's an obligation on the part of the state to supply a lawyer to people who have been charged with a crime which may result in imprisonment. And even that is controversial. There is no right to representation in civil matters. And if you walk into a civil court in the United States, you'll see many, many poor people who are there representing themselves and doing so very badly. Should there be a right to representation? I personally think there should be. Is it likely to occur? I don't think so. And in fact, what's happened in clinics routinely is that clinics get shut down, like my first Berkeley clinic, because politically they become provocative and controversial, because they are representing poor people who otherwise wouldn't be represented, and often representing them in cases against powerful people. That's what happened with my Berkeley clinic, and it happens every year. There are a few controversies involving law school clinics in the United States. At the University of Oregon, they built an environmental law clinic that started suing people from the timber industry. And so the timber industry went to the legislature and they said, shut it down. And the legislature shut them down. In Louisiana, there was a clinic that started working on cases involving the oil industry. The Louisiana legislature shut them down. In, what state is Baltimore? Delaware? Maryland. Maryland. Thank you. So much for my knowledge of U.S. geography. I'm glad somebody here knows it. In Baltimore, they started a clinic a workers' rights clinic that went after the poultry industry. Okay, did you know poultry was an industry? In Maryland, it is. Yeah, and the Maryland legislature shut down the clinic. So it hasn't been when the state decides to disengage, it's by shutting down clinics, not by celebrating the fact that the clinics are doing work that otherwise the state would take responsibility for. But in theory, you're right. And if you have a state in which people have a right to legal representation, then the politics change a little. Yeah.
I'm much interested in asking you how years of training and teaching shape your attitude towards lecturing and teaching with students. Has it changed a lot or not?
Well, in some ways, I mean, I knew from the start that it was important to use humor, and it was important to use learning by doing technique, and it was important to be concerned about engaging students, that I couldn't just sort of stand at the front of the room and lecture. But I didn't know how to do that. And we don't train. See, I actually had a little bit of training because I was a high school teacher. We train high school teachers, but we don't train professors on how to teach. We train professors on how to do research and how to write. So we train them a little bit on how to be scholars, but we don't train them on how to teach. I don't know if that's any different here. And so we just sort of throw our professors into the room and assume that they'll figure it out. Yeah, it took me a while to figure it out. So for example, I don't know if you've heard of a technology called clickers. But clickers are electronic devices that we can give to students, or students can actually load on their phones. And I teach using clickers extensively because they allow me to ask the students a question and everyone has to answer, but they answer anonymously and the results immediately go up on the board electronically. And it means that sometimes students realize that something that they thought was easy and where everyone agreed, in fact, they're evenly divided. Or sometimes I realize through using clickers and asking questions of students that they all get it and I can move on. Or they don't get it and I have to go back over it again. So, you know, that's something that I've learned only in the last few years. That's just has changed the way I teach dramatically. And then the other thing is learning how to critique, particularly in skills courses and learning by doing courses. And if you ever want me to do some workshops on this, for people, how many of you teach by using simulation, having students do exercises and then watching and then discussing what they did in the exercise? Like a trial practice exercise or an appellate practice exercise. Is that something you do?
Yes.
Okay. So I started out and I would watch the student do the exercise. Maybe I'd watch them all do them, and then I would give them a long critique in the form of a lecture. And then I took a course from the National Institute for Trial Advocacy that taught me that that was all completely wrong. So now I'll have the student do an exercise no more than 5 minutes, and then I will do a 3-minute critique. And in that 3-minute critique, I will point to 3 things. The first one, I'll say something good, even if it's really hard to find something that reaffirms something the student did. The next 2 can be critical, and if I'm critical, I give a brief demonstration of what I mean, so that I have to put myself in the spotlight. And all of it I videotape so that the student can review the tape privately and then further review it with me in my office. And so that's changed the way I teach advocacy techniques quite dramatically. And then clickers in my big lecture class so that it's more of an interactive discussion. I also encourage students to use their computers in the classroom or their phones to communicate back and forth, as long as it's about the material that we're studying.
about the porno.
If the classroom is not a place of trust, you know, it's not about control, it's about trust. And it's my job, it's my responsibility to be interesting enough that they're paying attention. If any of you right now are sitting there reading your email or shopping for shoes, it's not your fault, it's my fault.
Very good. This is a very good. Any other questions? Otherwise, we.
Nobody has questions because they're all reading their email.
Really kickers.
Clickers. I have to know what it is. Actually, I don't know what a clicker is.
Everything up there.
I don't have to.
Oh, I know, but I'm just going to just put the name up for you.
Okay, sorry. Yeah. Okay, in the meantime, if there is no other questions, I would like to thank David Oppenheimer for the time and for his absolutely interesting explanations. He will be here the entire afternoon, so he will follow us the discussions, and we can ask questions if questions come up. Thank you very much.
It was a great pleasure. Thank you.
Now I would like to ask the clinicians here in the room to come up with me, and I would like to give you a kind of an impression what the status quo of clinics is so far in Italy. So I would like to one representative from Brescia, from Teramo, and from Roma 3 to come up with me, so that we can explain to everybody a bit what is the situation in Italy. I would like to start describing what's so I will quickly place the clinical movement inside of the Italian clinical movement inside of the European clinical movement. So I will shortly explain you what I think happened in the last years in Europe and in Italy, and then describe a bit what actually is happening here in Turin specifically. I try to use this PowerPoint. Unfortunately, you can't really see it very well, but I will try to use it. Okay. But what happened in the last years? From the common law perspective, we have seen development of law clinics and clinical education in the UK since quite a number of years, 30 years I would say. And we do have now in almost all law faculties in the UK quite developed clinical education programs. The same happened actually in Eastern Europe after the changement of the political system, so after the 90s. Mostly because of the changement and the changement of legal education, but also because it was very much supported by local but also international foundations who helped developing those clinical programs in Eastern Europe. What we can, let's say, as an impressive example, point out is the example of Poland. Here you have now in all law faculties a clinical program. They run a specific type of clinic, in-house clinics inside of all law faculties, and they serve a high number of clients every year. And students, like for example, the Borsos Law School has 150 clinical students, and they serve more than 1,200 cases per year. And they take actually a strong portion of the legal aid support for social relevant cases who otherwise would not have access to justice. These actually happen, and this is something which is the critique that also mentioned here before, is actually something which is very much also linked to the specific case of Poland, where you don't have in reality a well-developed state legal aid system. And actually there were some new laws discussed in Poland where they the state tried to give the entire role of the legal aid to law schools and the law students, which obviously was against the fundamental and general principle of the law schools to educate people rather than provide a legal service. In contrast to this, the continental countries in Western Europe haven't really developed a lot of clinical programs, and even legal practice or legal skills courses and something like this haven't really been so much developed inside of the law schools. Richard Wilson indicated it as last holdout in the worldwide acceptance of clinical legal education. I think it is, he pointed out in a very interesting and very famous article that actually very much is linked to the history of legal education in our countries, but also the academic culture and the course structure, which is quite rigid, which not helps to develop such very individual and innovative courses. Nevertheless, in the last years, specifically starting from Spain in the early 2000s, clinical legal education came over in those traditional legal education or continental systems, and now we can find them almost everywhere, at least a small project in Belgium, in France, and in Germany, and of course in Italy. This led us to a development of a European network, which I would like to also share to all the others clinicians. There is a European network that has been developed last year, or let's say 2 years ago. It's called the European Network for Clinical Legal Education. And we started this experience in 2012 when we had our first meeting in Turin at the IUC. And then we had our first, let's say, conference last year in Warsaw. And the main objectives of this European network is to promote justice through education by using these new settings of legal education. This is the definition, which is, you can't read it, but it's quite interesting. It was a quite interesting challenge to define what is clinical legal education. What is a clinic? And I think we could have a discussion with David or with other clinicians the whole day long to decide what your opinion about clinical legal education is. In basic, I would say it's a kind of a experiential learning teaching method where you not only base yourself on content but also on skills development and values, but at the same time also promote social justice. In brief, this is something that we had agreed in common in Europe to have as a legal as a definition on clinical legal education. But I think it was, and I think it is also something that we should try to do in Italy to understand what we understand about clinical legal education. I think this is something which was a quite useful exercise for everybody to start with, and I would invite also all the students to think about what, in your view, after having done some clinical activities, what do you think is a clinic in your view, or should be, let's say. So I'm passing through quickly. There are some let's say objectives and aims that we would like to pursue as a European network. having conferences, creation alliances, and all this for the research, because there's not much on clinical teaching methods, for example, in Europe developed. A lot have been done in the United States and in other places in the world, South Africa, for example, but in Europe specifically, nothing really have been developed, apart of some interesting things from Poland or the UK. But I think something like this in the future is interesting to develop further. Everybody can be a member who has some alliances with being in or interest in clinical lead education. So I would encourage everybody who are here, actually as a teacher, as an interest researcher, or whatever kind of function you might have in a clinic, that you or interest you might have in a clinic, to apply if you're interested in this European network. We will have a conference, a second conference, which will be in July in Czech Republic, in Olomouc, on the 15th and the 18th. And we do have also a training on social justice for clinical directors, which will be in Brussels. Now I would like to pass through the, that was the frame how it is in Europe. In Italy, we have, I ask, I have to excuse if there's somebody who's not mentioned here, because there might be some project that I have no notice about. I just heard about that Verona is just starting a clinical, University of Verona is starting a clinical project. I know that, for example, also in Palermo there is a clinical project that started. But basically, this is what I was aware about. The first clinic was the clinic in Brescia, and I'm happy that Fabio can give us more information about how this clinic works. We have another interesting activity which is not called clinic, but is somehow working as a clinic, which is the University of Florence with the NGO Altro Delito, who is working on prisoner rights. Students are giving actually legal advice inside of prisons, and this is a very interesting example. We have Roma Tre, we have our clinics now in Turin, the Family Law and the Prisoner Rights Clinic, and this joint program on human rights and migration law, together with the University of Eastern Piedmont and the International University College. And then we have the University of Teramo on labor law, and unfortunately the University of Perugia was not able to come at the end, but they also have a very interesting clinic on prisoner rights and on environmental law. Now, what we have seen so far as a kind of a movement is that there is no formal organization, but we might talk about this this afternoon, how maybe we could try to create a more formal network. But at the same time, we have seen quite a number of activities. I remember actually 2 workshops in March 2011 on clinics in the University of Turin, and at the same time, in the same week, it was also at the International University College. Then we had a conference in February organized by the University of Brescia on clinical legal education in Europe. We had also last year a very interesting international conference on clinical legal education in Rome. And we had specific workshops, one last year in Turin on migration law clinics, and we also had a children's rights clinic workshop in 2000, I think it was 2012 in Rome. So some activities, you can see every year we had some specific activities where we combined clinicians, but at the end I'm quite sure that we should try to organize ourselves in order to link our experiences, to learn from each other, because we have specific problematics, in our universities, and everybody have focused and worked over this problematics in a different way, and it would be really interesting to share our experience and to see what is feasible. In Turin, we do have three, as I told you, three different kinds of clinics. The first is we started this year a clinic on Persona e Famiglia, which is a family right clinic, where students are actually working in support of persons in need. And there have two kinds of activities. One is in-house in the university, where they work on cases inside of the university, sometimes through simulation, sometimes cases that came from partners. And they have a kind of externship organized with the Turin Spa legal aid offices and also the information desk. We have somebody here from this information desk and can give us some more information if you want, from the Provincia di Torino. Then we have another clinical program which is called Carcere e Diritti, which is on prisoner rights. Students are actually creating awareness about prisoner rights and their application in practice, and they get those awareness about the involvement on cases of prisoners through lawyers coming into the university and explaining those cases, but also the involvement and visits in the prisons of Saluzzo and Asti. And then we have also people here who can explain more if you want in the discussion maybe. And then we have our human rights and migration law clinic, which I told you already is a kind of combination of a cooperation between three universities: the University of Turin, the University of Eastern Piedmont, and the International University College. And we are working partially on real cases, on externships, and also with lawyers together, but also on practical research studies that we develop on prisoner rights, let's say on detention rights of migrants, and we try to prepare some strategic litigation activities. Okay, now I would like to, maybe you would like to start? Okay, I decide that Enrica is from Rome will explain you. Okay.
Okay. Thank you very much, Ulrich, for your presentation, your introduction, and thank you everybody for inviting me. Ulrich asked me to present the clinical programs that are currently running in Roma Tre University. And we are actually running 3 clinics. One clinic on migration, asylum and citizenship, which is the one that I coordinate, and is a course, is a regular course worth 7 credits. We have a clinic on the rights of children, which is as well a course recognized and worth 7 credits. And we have a new clinic which is started this year on savers' rights, which is what we call a attività integrativa. I wouldn't know the equivalent in English. Anyway, it's a series of seminars worth 3 credits. And each clinic has got specific activities. Within the clinic, the students can undertake specific activity. In the case of the clinic on migration and asylum, besides the legal clinic course, we have a front office. I think it's the only example of an in-house clinic in Italy, we have a front office where students offer legal consultancy to migrants and asylum seekers who come to the university. And also we undertake research activities, and students are actively involved in research activities. The clinic on minor rights works in a slightly different way, because there is the legal clinic course, but the front office activity, let's say the practical activities, is now within the university, but the students go and have an internship with the Save the Children office, and is a clinic run in collaboration with Save the Children. And the clinic on civil rights, which just started, is only a course, a series of seminars, and is run in collaboration with Banca d'Italia. So, of course, they are very different, these three clinics, also in terms of what the issue that Ulrich was addressing about engagement and involvement in social issues. The first clinic was established 4 years ago and is a clinic about migration, and was established thanks to the initiative of a group of students and the clinic's coordinator. I think this was a very important point, because for us it was a way to bring inside the university the issue of migration. There wasn't a course on migration law or any structured activity dealing with migration. And following the first successful experience of this clinic, over the last 3 years, the law department has encouraged the development of clinical legal education, also recognizing 7 credits for the legal clinic courses. I speak about successful experience because we were successful, especially in raising funds for the clinics, and this was something quite important for us to be recognized inside the university. Recently, also the university chancellor has recognized the importance of clinical education within the university's third mission. This is for us a new issue. We haven't yet developed a proper document about clinical education and third mission, but maybe it's something we can explore. Then Ulrich asked me to spend a few words about the clinic on migration and asylum. The clinical program on migration and asylum is attended by law students in their last year of the course of study. And as I said, it's divided into 2 modules, a clinical course and a front office, where a student provides legal advice to migrants and asylum seekers. Here in the, you cannot see the picture very well, but there is a session of the course, while in this other picture you can see a session of the front office. And the front office serves around 100 migrants per year, which is a big number for us. We were not expecting such a this front office, this information point, would become a point of reference within the city for migrants and asylum seekers. And in 2013, students contributed to more than 15 appeals against deportation and asylum decision. Of course, I don't like the word clients anyway, migrants and asylum seekers are represented by lawyers who collaborate with us for free, they volunteer, and students of course help the lawyers, but they do really a lot of activities and they also write part of the appeals, for example, especially with regarding international protection and asylum matters. So, I tried here to list what I think are some of the strengths and also weakness of our clinical program. Is an approach that combines practical experience and theoretical knowledge. I teach legal philosophy, so we also try to contextualize the cases in wider debates about, theory of rights, theory of justice, and this kind of debates. The clinic is deeply rooted in the local urban area. We have many contacts with associations, migrant groups. We built many contacts over the years. And I think this is also important because what we try to do within the clinic is also to build legal culture as what we call common knowledge. So to transmit a kind of knowledge which is not, which comes from below, that is produced together with the students, but also together with the people that come to the clinic. But okay, I go to the last point and then I come back to the students' initiative because I think the main problem we have is the lack of recognition from the academic community as a whole. I mean, clinical programs are not evaluated by the Italian agency for the research, AMBUR, for example, just to say something, are not. It's not possible to list clinical programs in the CINECA system and all these kind of problems, but also as something similar to what Professor Oppenheimer was describing. Clinical features are seen with a little bit of suspect within the faculty. And I want to spend a very few words about the students' initiative. As I said, the Clinic on Migration and Asylum started with a very strong contribution from the students, but also students took their own initiative, and now they have some parallel projects that they run on their own. For example, they started an information point in this place called Salam Palace, which is a building squatted by around 1,000 asylum seekers in Rome. And also they started a consultancy, they gave this name to the project, consultancy in the field, an itinerant information point with the migrant workers in the agricultural sector. And this is, now you can probably see the picture, but this is the picture which portrays one of my students in Rosarno, in the countryside in Calabria. where they went to give and to set up an information point with the migrant workers there. So I think I said everything about our clinical program, but I hope that
Non è che non sia felice, guarda che una roba del curriculum è stato fatto, che seguito, vogliamo attaccare. Questo è un core issue già nella mission dell'università.
Okay, can you hear me? Yeah. First of all, I would like to thank you, Ulrich, for organizing this very interesting meeting, and thank you for inviting me to give this short talk. I would like to give you a short description of our clinic, and then I would like to raise some problems, and then we can discuss later during the debate. Now, just very few information about our clinic. The clinic was established in 2009, so 5 years ago, and at the Faculty of Law, now the Department of Brescia. And is a multidisciplinary clinic, so we handled various cases involving various subjects. I'll tell you something more later. And so since we handle a number of different cases, I'm not going to talk about any specific case. I would like to talk to you about how our clinics is organized, and I would like to talk about some problems we had to deal with when we had to establish the clinic and run it. As the model we decided to adopt is a hybrid model. What does it mean? It means that we don't have an in-house clinic because we don't have such a figure as the traditional clinical professor as in the United States they have, and that's a problem because all the people involved in our clinic do their own job. They teach criminal law, labor law, whatever you want, and they do an extra work to run the clinic. And I think that this problem, this raises some problems in terms of sustainability of the clinic in the long run. So that's a problem we should be discussing, because for the future development of the clinic, I think it's a crucial issue. And with regard to the activity we perform, our clinic is based mainly on litigation. So we do a number of other activities, legal advice, amicus curiae briefs, but it's mainly based on litigation. And so it's a live client clinic in this sense. These are the subjects, cases we handle. You see, there are various subjects involved: civil law, criminal law, criminology, international and immigration law, labor law, anti-discrimination law, administrative law, and the newcomer, the new entry, is mediation. And that's important because the introduction of a mediation clinic was highly recommended by the local bar association. They were very interested in introducing a mediation clinic. So this could be a piece of advice if you want to involve your local bar association in the management of the clinic. That could be a good way to involve them, because the Brescia Bar Association proved to be very interested in mediation, and that was a way to involve them more deeply in the clinic. And some statistics. These are we handled since the clinic was established. We handled 44 cases, and they are distributed. I don't know if you can see the graph, but basically criminal law, international and immigration law, and civil law. And then some cases on labor law, anti-discrimination law, administrative law, criminology, and so on. And who can take legal clinic? Our legal clinic is offered, the course is offered to students enrolled in the 5-year degree course in law, the so-called laurea magistrale. And it's offered to students enrolled in 3rd, 4th, or 5th year of course. And it's also offered to students enrolled in the 3-year degree course for labor consultants who are in their 3rd year. And as to the general features of the clinic, it's an elective subject, so it's not mandatory, of course, but it's an elective one. It worth 6 credits, so it has a formal recognition in the curriculum of the students. And students can take legal clinic in fall term or in the spring term. So we have legal clinic 1 and legal clinic 2. They can take 1, 2, or both as they like.
Both is 12 credits.
Yeah, because they have two courses of 6 credits each. These are the students enrolled in the period 2009, so when the clinic was established up to now, and you see there was a significant increase. There was a period of adjustment in the 2nd year, you see, but the number is constantly increasing. So at the very beginning, the students were a bit skeptical towards the clinic, as some of my colleagues were. There was a bit of skepticism. They were a bit reluctant to accept this new method, but with a bit of patience and a bit of marketing and probably we did a good job in the clinic. Every year we have more and more students. Well, as to the goals, I'm not saying anything new in the sense that the goals are typical goals of the clinical legal movement, so I'm not saying anything more. As to the activities performed by the students, 3 kinds of activities. There are joint activities which all the students have to do together. For example, rounds where the cases are discussed all together. Seminars, simulations, classes of ethics. And this is very important because the local bar association insisted that we gave classes on ethics. Classes are held by members of the directive board of the bar association, to come to our university and give the classes on ethics. And introducing seminars of ethics was another way to involve the local bar association, which was very sensitive in this respect. They are very concerned about ethics. So I can't even imagine a clinic only run by students without compliance with ethics as it happened in Berkeley, because I think the local bar association will kill us all if we allowed such a thing. But anyway, I have to say that the local bar association, after a first moment of skepticism, was very, very supportive, and that was very important for the development of the clinic. Of course, students have to do some teamwork. Students are divided into small groups formed by, let's say, 3 persons, 3 people for 1 case. That would be the ideal ratio. Sometimes it's not possible. For example, where we have a lot of students. For example, this year we had 65 students enrolled in the clinic, but they were distributed not homogeneously. So there were 50 students in the first semester and 15 in the second. So obviously in the first semester we had to form larger groups, let's say 5 people, 5-6 people. But the ideal ratio would be 1 case for 3 students, in our opinion. And each group is supervised by 1 teacher and 1 lawyer, so 1 teacher of the university staff and 1 external lawyer who is in charge of the case, because of course students cannot represent directly the client. Although they can do a lot of activity, they interview the client, they write letters, they write briefs, memos, they write claims under the supervision of the lawyer, of course. They can attend hearings, and if the judge allows it, they can also talk during the hearings. It depends on the judge. And of course, students must do some individual work, individual study, individual research, an activity of self-reflection, which is very important and it is very in educational terms. As to the evaluation of students' activity, which is a big issue because it's not easy to evaluate students' work, we take into account a number of different factors. Regular attendance at classes. Classes are mandatory. So if you don't come to a class, you must have a good reason. Otherwise, this has an impact on the evaluation, a negative one. Individual commitment, the quality of document drafted under the lawyer's supervision. Of course, the document, claims, memos don't have to be perfect because we don't expect a student to write a perfect claim, of course. We evaluate the improvement from the beginning to the end of the course. And they have to write a report on the activity performed, concerning not only the description of the case, but also reflection on the experience they made in the clinic. And this is a part of self-reflection, which is very important in our view. And we also give them some questionnaires to be filled in, where they judge the teachers. And this is important for us because it's a learning by doing process also for the teachers, not only for the students. And now just a couple of minutes to talk about the future developments of the clinic and to talk about a specific process we are working on. We call it the Labor Clinic Project. What is the Labor Clinic Project? The idea is to develop the full potential of the clinic by using the clinic for the purpose of the traineeship required to become licensed professionals. You all know that to become a licensed professional, a lawyer, an accountant, a labor consultant, you have to get a degree, of course, but you also have to go through a period of traineeship of 18 months right now. And but you probably know, well, the teachers of course know, but as the students probably know that there's the possibility after the decree number 1 2012 to do a part of the traineeship period at the university during the last year, 6 months out of 18. So now our idea is that the clinic is the right place to carry out the 6 months of traineeship at the university. There can be many ways to do this traineeship at the university, but we believe that legal clinics is one of them, and probably the most effective one. And so, what have we done? Well, in July 2013, the National Labor Consultant Association, the Ministry of Education and the Ministry of Labor signed a framework agreement on traineeship. And Marta Barbera, some of you probably know Marta Barbera, went to Rome to talk with the president of the National Association of Labor Consultants to discuss the possibility of using the clinic for this purpose. And the labor consultants at national level were very interested in this project. And so now we are negotiating this matter at the local level with the local association of labor consultants. We are negotiating the contents of a local agreement that will establish how the clinic can be used at the University of Brescia for the purpose of the traineeship. And what are we discussing with the local labor consultants association? Well, first of all, the activity to be carried out in the clinic within this project. There are some proposals we are discussing. For example, you see a list of possible activities to be taken into account for the purpose of the traineeship. Legal advice, this is the most obvious one. Second, participation in the procedure of certification of employment contracts under the decree number 276/2003. Of course, the clinic cannot certificate the contract because there are specific conditions in charge of it. But students could contribute, give a contribution doing a number of preparatory activities useful for the certification. Quality of work certification. And we could also provide support services for small business startups, especially for social cooperatives, so to remain linked to the social commitment of the clinic. We've been discussing the students' participation requirements, for example, if it's needed or not, a grade point average and what contribution in practice can the labor consultants give in financial terms and in terms of activity performed in the clinic. So there are a number of things we've been discussing. And, but we think that this could be a good way to spread the clinical movement all over Italy, to involve the professional association, labor consultants, accountants, lawyers, because I think that this is crucial to the future development of the clinical legal movement in Italy. Thank you.
Grazie per l'iniziativa. Io non ho preparato una relazione in inglese, ma ci tengo comunque a dare sinteticamente una presentazione del lavoro che stiamo facendo a Teramo. La nostra, anzitutto, è un'attività esclusivamente didattica, la nostra clinica di diritto del lavoro, e quindi diciamo molto simile all'esperienza di Brescia. Ora ci sono alcune differenze che ci confronteremo magari più tardi, eccetera. La nostra opzione è stata quella di concentrarci su una visione puramente didattica, un po', devo dire, prevalentemente per una scelta di campo, no? Nel senso, non abbiamo voluto inserire gli studenti in un'attività di assistenza legale per il momento, e un po' anche perché ho registrato nella facoltà un certo timore per quanto riguarda i profili della responsabilità, e anche perché nel campo del diritto del lavoro l'assistenza, il patrocinio è essenzialmente svolto dalle organizzazioni sindacali. Questo quindi, diciamo, non rende particolarmente attrattivo, diciamo, lo sportello di diritto della clinica di diritto del lavoro in un'università, probabilmente, però non è escluso che nel futuro si possa riconsiderare anche questo aspetto. La nostra clinica è un corso di studi, è un corso opzionale che vale 6 crediti formativi e diciamo, si colloca più o meno negli ultimi anni del corso di laurea in giurisprudenza, e quest'anno l'abbiamo organizzata avvalendoci della forte collaborazione degli avvocati giuslavoristi che sono organizzati in una loro associazione specifica che si chiama AGI e che stanno collaborando in maniera molto significativa con l'attività della nostra clinica, ma ovviamente lo fanno in una prospettiva di collaborazione con tutte le cliniche di diritto del lavoro eventualmente operative in Italia, nelle nostre università. Come abbiamo organizzato questa attività, che noi concentriamo solo in un semestre, e questo è già per noi una grossa difficoltà, perché dover concentrare la partecipazione di studenti ad attività di tipo professionale nel corso di un semestre rende impossibile concentrare lo studente su un'intera attività di assistenza legale, no? È il tempo del corso che impedisce di far seguire ad uno studente tutto un processo legale, che sia un processo giudiziale o un'attività di consulenza stragiudiziale. Allora, il metodo che noi abbiamo seguito è stato quello di frazionare l'attività di assistenza legale su singoli frammenti concentrati nel corso del semestre di riferimento. E come abbiamo fatto? Abbiamo chiesto a alcuni avvocati di studi molto importanti, iper specializzati nel diritto del lavoro in tutta Italia, abbiamo chiesto a alcuni di questi 5-6 colleghi di portarci un loro caso a Teramo. Siamo stati, diciamo, preavvertiti del contenuto del caso, abbiamo avuto quindi in anticipo la documentazione sulla quale gli studenti sarebbero stati coinvolti e avendo acquisito la documentazione io ho organizzato il ciclo per ciascun caso, un ciclo di 3 incontri. Il primo incontro, che è quello gestito da noi universitari, che ha presentato l'aspetto teorico del caso che avrebbero affrontato. Il secondo incontro con il professionista che ha portato il caso concreto con la documentazione reale del caso, quindi il ricorso, la memoria di costituzione o i singoli aspetti che nelle diverse casistiche abbiamo affrontato, e all'esito dell'incontro col professionista, il professionista ha dato agli studenti un compito, come se fossero i loro praticanti di studio. No, questa è stata un po' la logica che noi abbiamo seguito. Quindi l'avvocato si confronta con i suoi praticanti di studio, che sono gli studenti dell'università che noi abbiamo prima preparato dal punto di vista teorico su quel caso, e quindi gli affida un incarico che è il completamento di un atto giudiziale, che in alcuni casi è stato proposto agli studenti come traccia da completare, da arricchire, l'approfondimento di una problematica giuridica specifica con delle ricerche di dottrine e di giurisprudenza tarate su quel tipo di problema, e via dicendo. Il terzo incontro è la produzione che gli studenti devono eseguire, cioè eseguono, diciamo, su input dell'avvocato, che viene discussa collegialmente in aula, no? E poi sottoposta ad una valutazione separata sia dei docenti del corso che degli avvocati che hanno collaborato con gli studenti in quella casistica specifica che è stata affrontata. E questo lo abbiamo ripetuto per 4 casi diversi, ovviamente tutti concentrati sul diritto del lavoro, e l'ultimo caso che presenteremo invece cercheremo per la prima volta, e questo per noi è una nuova sfida, cercheremo di coinvolgere gli studenti in un rapporto, diciamo, completo con avvocato, cliente dell'avvocato e docente universitario, per cercare di fargli seguire quanto più possibile il processo dal momento in cui nasce, cioè dal primo incontro tra l'avvocato e il cliente, al momento in cui viene definito con la sentenza. Ecco, ancora non ho ben presente come sia possibile coinvolgere gli studenti in un arco temporale così lungo, perché evidentemente eccede il corso della clinica legale, ma ci stiamo ragionando e cercheremo di trovare, anche magari grazie a questi incontri che per noi sono preziosi, cercheremo di trovare le soluzioni, diciamo, più congrue, più ragionevoli, no, per il caso. Mi sento di condividere pienamente il progetto lavoristico sul quale state lavorando a Brescia, no, che assolutamente è completamente in linea con quello che stiamo cercando di fare noi. Voi lo state cercando di impostare con i consulenti del lavoro, noi ci stiamo concentrando di più sull'associazione degli avvocati giuslavoristi, perché pensiamo di concentrarlo più su un tipo di attività prevalentemente tecnica, prettamente legale, più che di consulenza del lavoro. Però ecco, la logica mi sembra sia assolutamente coincidente, quindi questo magari mi farebbe piacere anche continuare a confrontarci su questo sviluppo delle nostre cliniche giuslavoristiche. Grazie.
No, I don't know what to speak, but let's turn to English because there are some of international students still around, and let's give some minutes of possibilities to questions. But at the same time, I would like to tell you that we will have a second part where we will be much more the possibility to discuss more in detail what kind of practical problems we face together as a. So maybe if some students who might not be around for the second part would like to ask some questions, please come around. Otherwise, I open up for everybody for specific questions that you might have.
I didn't really understand the Savers clinic in Rome. How does it work?
I do not run the Saver clinic, but so I only have some information. So from what I know, is a clinic on the right. I mean, the original idea was to set up a clinic on the rights of consumers, but then they didn't find a specific support for this. So on the other side, they found the interest. They met the interest of Banca d'Italia. And so they decided to start a clinic on savers as consumers. And the clinic is centered on arbitration, so I think it's centered on alternative dispute resolution. And that's it. It just started really few weeks ago, so I don't have more information on this.
And perhaps the only one who's not a lawyer in this room, and I'm asking for intellectual asylum. One question that I have is, why is it a problem that a clinical instructor is not an academic instructor as well? Why would it be a problem to have a course, a clinical course, which is also an academic course? I'm saying this because in my mind, and I'm not a lawyer, there is a clear distinction between traineeship and clinical education. It should be two different things, and we should, I think, reserve to our European understanding of the world that these two things are to be distinguished. Thank you.
I don't know if it's a question for me, but I absolutely agree. And actually, for me, but right now I'm expressing my own opinion, the University of Toronto opinion. For example, I'm not sure that I want a strict involvement of bar association in clinical legal courses. It depends, but for example, I do not think that a bar association should, for example, appoint the lawyer. Because for me it's a matter of, university education must be independent. So I completely agree, and I also completely agree that it would be very important, especially in this phase that clinical education is started in Italy, to define it in a very clear way and to define it as something different from an internship. We shouldn't be scuola forense, sorry for the English speakers, but it should be, it should be something different. So I don't know if I understood what you meant and what was your point, but
Yeah, that's the point.
yeah,
That was the point.
that's the point. And I believe, that it shouldn't be not compatible academic approach and clinical education. If I may add something, I was very quick in my presentation because I didn't know how much time we had. But I think one of the points is how the academic community see clinical education, especially law faculties, are not normally very open to such a big involvement, for example, of students in deciding what should be an alternative way of learning and teaching. And in a clinical course, I think it's not possible to avoid the fact that the relationship between the teacher and the student is much more an horizontal relationship. That's what I tried to say before when I was speaking about building knowledge together with the student and also with the people outside. So this is my.
Can I say something?
Yeah.
As to the problem of traineeship, because I was not very clear when I talked about it. We do not think, of course, that clinical legal education and traineeship is the same thing. We know they are very different things. And we are not going to turn legal clinics into a traineeship experience. What we're trying to do is to convince, in our case, the legal consultants, that the legal clinic can be an experience useful also for a future professional. And so we are asking the labor consultant to recognize the legal clinic and the activity performed in the legal clinic as a possible part of the traineeship. But it would be clinical legal education activity, not traineeship.
Yeah.
But we are trying to convince them that clinical legal education would be useful for them.
Thank you for the clarification. By the way, our 12 months of joint program are recognized as 6 months of traineeship by the bar of Turin, okay, the law bar of Turin. So I have nothing against a recognition of the traineeship, but I do think that irrespective of some American experience, we can handle the clinical education in a slightly different way. For instance, we are told that 50 hours of pro bono activity are necessary now in New York to take the bar exam, but that is again a point which is aside, okay, accessory to legal education, which is something else from pro bono activity per se.
Right, but the law schools may have responsibility for providing the opportunity for the students to engage in that pro bono activity as part of their responsibility that the students, when they graduate from the law school, will be able to take the bar. Because in the U.S. we don't have the interim period of apprenticeship supervised by the bar. So we've been given an added responsibility.
I'm working on a different project, but I find myself again facing the same problem. I'm supposed to involve public authorities in our research program because it's not difficult to involve lawyers or associations or NGOs, but when dealing with public authorities is always a huge problem. And on one side, we don't want to involve them because we think that to have like an independent research, we don't want to involve public authorities. But at the end, we face the fact that we have to work to have a complete analysis. And this year, I'm working in the Observatory of Judicial Budget, and I know that wrong, so and again, we are having programs to get this authorization to be able to do the decisions of the judicial budget. And I want to know how the other clinics are dealing with this kind of problems, if they have to be.
What kind of public authorities, as well as, for example? But for example, if I can just give a short answer, we handled 2 criminology cases, and we have a professor of criminology who works with prisoners, people in jail. And last year, no, it was not a professor of criminology, it was a criminal law case. The people, the students had to meet the client, he was kept in jail, so we asked a permission to let the students enter the prison, talk to the client, and we had many problems in the relationship with the public authority, because it was not forbidden. We were saying that it shouldn't be forbidden. I can find any rule against the possibility for students to enter the jail and talk to them. But if I don't find a rule that expressly allow it, I would say no. That was the attitude of the public authority. And so now we are trying to work on the relationship, for example, with the jail authorities to let the students enter the jail to talk to the client, which is an essential part of the case, the relationship with the client. For example, this was one problem we had with public authorities, and we're trying to work on this to work it out in some way.
Actually, I just give maybe the feedback of the background of this case. Is that actually we faced 2 times problematic of getting access to the detention center, and this year we get a continuous problem on having access on the files of the due departure on detention. So those kind of authorizations and our kind of contact to authorities in the migration field are somehow quite difficult. But I guess somehow it's the same also for the prisoner rights clinic to get access to the detention. And maybe if you would like to say something about how do you get access and how this.
I think it's not just there is not a real problem for the authorization to enter in a prison because you have to ask it. Of course, you have to have the authorization for your students, but you have to be authorized by the judge, by the surveillance judge. And we hadn't specific problems for this point during, of course. And I think you wanted to say another thing, another kind of collaboration, not for this kind of authorization, but for example with the Center for Identification and Exclusion in Turin, or for example for the research with the Luigi. These are real great problems.
I can only say that as a legal clinic, we together, because we are running the project together, the research about judicial departure together, we made the case out of these difficulties of entering the decision of judicial departure. So we had to study all the rules about the publicity of judicial decisions that I thought was a clear principle of the rule of law, but apparently is not. And we had to make case arguments, and now we are still dealing with this case. So I think that's.
If I may can say, I mean, in the United States, clinics have been cancelled.
Yeah, exactly.
So we are not yet there. So we just try to ask for authorization. So
some years ago. Not some years ago.
There is this related question, if I understood your question correctly, about our right as academics to research material. That if we're running a clinic in which we are engaged with public authorities, is there a rule of law principle at the level of the state that permits us to gather and publish the data generated by our clinical work? And that's important if we are engaged in clinical education and research rather than simply providing legal services or providing training. And so if I understand your question correctly, it goes to the heart of what makes what we're doing different and sometimes more challenging, but also important in terms of it being part of the work of a university.
In Italy, somehow we have more the rule of man than the rule of law, and with that we can handle, like in Alessandra, we do that. with the prisons and the director and then the educatori there, and so.
We have some clinics in the United States that sometimes represent clinics in bringing cases under our Freedom of Information Act. And I don't know if there's an equivalent code provision in Italian law that gives us a theoretical right to information held by the government. And of course, the government has an awful lot of information.
Oh, yeah.
Some of which we're not supposed to know.
Okay. Other questions? If not, I would close this first part, and we will change the room, right?
Yeah.
We go to the room. You have to guide us because we're the people from the University of Turin. It's downstairs. I can Laurea Rosso. That's not Laurea Rosso.
In the building D1.
Okay, it's very close to the entrance where you have the Toro.
The ground floor D1. The ground floor D1.
Ground floor D1.
Okay.
Okay, so I would say we start at 5. No?
Okay.
Let's give us 20 minutes to find. Thank you.